every member of this committee to release documents that she or he believes are appropriate, and to delegate this decision to an unappointed and unconfirmed and largely unknown figure, Bill Burke, who used to work for the nominee, is the height of irresponsibility. Thank you.
I want to start by pointing out that when this part of the discussion started last night, I was concerned that, as with any witness in any courtroom or any proceeding before this committee, I want to make sure that when a witness is questioned about a particular document, the witness has access to that document. It's not fair to the witness who has, over the course of his career, been involved in the creation, the authorship, the review of not just hundreds of thousands, but many millions of documents in his lifetime. It's not fair to this witness or any other witness in any other proceeding anywhere to not give the witness a copy and allow him to respond to it while he's being questioned about it. So that's why I offered to Senator Booker, and Senator Booker and I had a helpful conversation with the very helpful committee staff last night, and they've agreed in the meantime to release this same document that was now the subject of it. So the process worked. It works. We do have the ability to make these things available, to make them public, so that we can be fair to Senator Booker, we can be fair to the witness, to the nominee. I do want to point out, since the charge has been made that this process is somehow rigged, that it's charged, that it's unfair, that it's arbitrary, that it's capricious, I completely disagree. We are not dealing in a lawless environment here. We're dealing here with the Presidential Records Act. We've got documents that are the subject of privileges, privileges that have to be asserted. Now, Bill Burke is the designee for that presidential administration and has the prerogative of asserting privileges, but through an accommodation with the Senate Judiciary Committee, to allow us to gain access to other documents to which we would never otherwise be able to have access. They have agreed to hand those over with the understanding that we have this committee confidential process, and that there are means by which we can clear documents like this one that we would otherwise not be able to clear. It worked here, it's been cleared, and I think we should move forward. Thank you.
Mr. Chairman.
Senator Durbin or Senator Feinstein, whichever one wants to go first.
I'd defer to Senator Feinstein.
Well, I will accept it. Thank you. It's my understanding that by agreement with private lawyer Bill Burke, the chairman has designated 190,000 pages of Kavanaugh's records committee confidential. And by doing this, Republicans argue members can't use these documents at the hearing or release them to the public. Unlike the Intelligence Committee, and I've been a member for about 2 decades, the Judiciary Committee doesn't have any standing rules on how and when documents are designated committee confidential. Previously, the Judiciary Committee has made material confidential only through bipartisan agreement. That has not been done in this case. So this is without precedent. Republicans claim that Chairman Leahy accepted documents on a committee confidential basis during the Kagan administration. It's my understanding that those documents were processed through the National Archives, not private partisan lawyers, and Republicans agreed. 99% of Elena Kagan's White House records were publicly available and could be used freely by any member. By contrast, the committee has only 7% of Brett Kavanaugh's White House records, and only 4% of those are available to the public. No Senate or committee rule grants the chairman unilateral authority to designate documents committee confidential. So I have no idea how that stamp, committee confidential, got on these documents. I sent a letter on August 10th, 2018, objecting to the blanket designation of documents as committee confidential. I offered to work with the chair. He refused. Judiciary Democrats sent the chairman a letter on August 28th, restating the objection to the chair's designation of the documents as committee confidential and requesting public release. As I've looked at the documents that are committee confidential, they do not affect any of the usual standards that would deny committee confidentiality. And, Mr. Chairman, I think that's a problem. I think we're entitled to all records, and I think the public is entitled to all records that are appropriate and do not put forward personal information or information that otherwise should not be disclosed. So I do think we have a problem, and I think for the future, we ought to settle that problem with some kind of a written agreement between the two sides, whether that's an agreement between the two sides of the entire committee or between the chairman and the ranking member. I think it doesn't matter much, but I think the fact is that we should agree on who determines something is committee confidential, what the criteria are for, and the release to the public, and particularly in the event of a Supreme Court hearing.
Senator Durbin.
Thank you, Mr. Chairman. And like my colleague, Senator Whitehouse, I don't want my silence to be interpreted as consent to the process that we've faced before this Senate Judiciary Committee. It is unlike any process I have ever seen. This designation of committee confidential should be put in historic context. There will be an opportunity for us later this afternoon to meet in confidential and secret private session to discuss this nominee. That is not unusual. It is done for virtually every nominee. Some of the meetings are literally last a matter of a minute or two, and we say there's nothing to talk about, and we're leaving. But it's happened in the past. But whenever we dealt with committee confidential, it was something that was very specific and usually very personal to a nominee. And it was done by bipartisan agreement that we would protect the nominee from assertions or comments that may not have any truth to them whatsoever, but the committee should take into consideration. That is a far cry from what we have faced with this nominee. I cannot understand, and I said this on my opening statement here, the authority that we have given to a man named Bill Burke, a former assistant to the nominee, that we have said to Mr. Burke, you will decide what America gets to see about Brett Kavanaugh. You will make the decision as to which documents we will be allowed to discuss openly and publicly and which documents we cannot. Who is this man? By what authority could he possibly be denying to the American people information about a man who is seeking a lifetime appointment to the highest court in the land? The National Archives is usually the starting point of this process. I put in the record yesterday a statement from the National Archives disavowing this whole process, saying this is not the way we've done this in the past. We usually initiate this. Please give us a few weeks to do it in an orderly way. But the decision was made by the White House and the administration not to go down that path, not to take the same course we have on previous nominees, but instead to allow to this gentleman, Bill Burke, a private attorney, the authority to decide what the American people can see about the background of Brett Kavanaugh in other capacities. Who is Bill Burke? All that I know of him is that he was once an assistant to the nominee. I am told that he is not only the attorney for George W. Bush, but also for the White House counsel, Mr. McGahn, Mr. Priebus, the former chief of staff to the President of the United States, and Steve Bannon, a man whom I couldn't characterize in a few words, but he's his personal attorney. And in this situation, he is now the litmus test. He's the filter to decide what the American people will see about this nominee. And that's why we bring this issue before you. Lest you think we are carping on a trifle here, we are talking about whether the American people have the right to know. And we now know that less than 10% of the documents reflecting the public career of Mr. Kavanaugh have been made available to this committee. And I just want to say to my colleagues, and particularly my colleague from New Jersey, I completely agree with you. I concur with what you are doing, and let's jump into this pit together. I hope my other colleagues will join me. So that if there is going to be some retribution against the senator from New Jersey, count me in. I want to be part of this process. I want to understand how Bill Burke, this private attorney, has the right to say, as one of my colleagues mentioned, this should be considered a classified document, a top secret document, a document that relates to the national security of the United States. By what right, by what authority can Mr. Burke possibly designate a document as committee confidential? He has no authority to do that. He only has authority because he has the consent and the cooperation of the Republican majority on this committee. That is the only thing that brings us to this moment. And let me just say in closing one last thing. I am sorry that one of my colleagues has characterized all of us on the Democratic side on the first day of this hearing as contemptuous. I have never heard that said before in a full committee meeting, but it's been said. And I'm particularly sorry that he singled out one of our colleagues on this side and accused him of conduct unbecoming a United States senator. I think statements like that are personal, they are disparaging, they question the motive of a colleague, something that we should do our very best to avoid in the United States Senate if we're ever going to restore the reputation of this body.
Mr. Chairman,
Mr. Chairman,
may I make just a brief point? Mr. Chairman, I'm looking at a Wall Street Journal article back during the Elena Kagan nomination. It says, document production from Elena Kagan's years in the Clinton White House. Counsel's office was supervised by Bruce Lindsay, whose White House tenure overlapped with Ms. Kagan. Bill Clinton designated Mr. Lindsay to supervise records from his presidency in cooperation with the National Archives and Records Administration under the Presidential Records Act. So President Bush, by choosing Mr. Burke, is doing exactly what President Clinton did in choosing Bruce Lindsay for that same purpose.
Mr. Chairman,
Senator Kavanaugh was first.
I thank my colleague. Count me in too. Mr. Chairman, I too referred to a so-called committee confidential document deemed such by one Bill Burke, and we all know who he is at this point. And had the nominee asked me for a copy of that so-called committee confidential document, I would have been happy to release it to him or give it to him. I am releasing that document to the press, and I would defy anyone reading this document to be able to conclude that this should be deemed confidential in any way, shape, or form. Thank you.
Mr. Chairman, I know you've mentioned a number of times that I went through the process. I do want to point out, however, that I also was on numerous letters asking for all these documents to be released, and that my colleagues have repeatedly asked for documents to be released. And I go back to what happened on the first morning of this hearing, and that is that we pointed out that when there are 42,000 documents that are dumped on us on one night, there is absolutely no way people are going to be able to adequately review them. And as they review them, they're going to find documents that they want to be made public, that they want to ask the nominee about. So the whole point of this is because this hearing was ramrodded through, and we weren't given, say, maybe the month it would take to look at these documents, we are where we are. So my remedy for this, in addition to making it clear that I join my colleagues that we support what Senator Booker is doing here, is that you must somehow expedite the review of every single document, and we must have some kind of rules in place to get them out. I understand you'd want to take out Social Security numbers and things like that. That's normal. But we simply cannot hide these documents from the American public. It is the highest court of the land. And I was looking back at, everyone was citing people, the founders of this country, and I found a quote that really works here by Madison. A popular government without popular information or the means of acquiring it is but a prologue to a farce or a tragedy. That's what we're talking about here. By ramrodding this through for political reasons, by denying us the access to the documents, we're denying the public the right to see what's out there. And it's just not how we do things in my state, and it's not how we've done things in this committee.
Mr. Chairman.
I'm going to call on Senator Lee and then you, but before that, a couple things she just reminded me of in her comments. Number one was to take care of all the people that didn't act promptly like you did, Senator Klobuchar. That's why we extended it and gave the courtesy of doing whatever anybody else wants now, and those can either be brought up now. Those that you've got can be brought up right now to him, and the things that aren't cleared that you want to bring up with the judge, you can bring up in the closed session today. And the other thing is, when you talk about getting all the documents, I don't know who might work for members of this committee sometime, want to be on the Supreme Court, and for instance, would you? We didn't ask for all the documents that Kagan had and emails or whatever communication she would have had when she worked with Senator Kennedy. Would you want to be exposed to that sort of thing if you want everything to be made public, or all the emails that you have, whether I think they're protected for 50 years for United States senators? So you're talking about the public right to know. Do you want to give up your emails right now? Make them public? I don't think you do. Senator Lee.
First of all, Mr. Chairman, I want to say I'm deeply sympathetic to the frustration people feel when they don't have access to documents they want. As a United States Senator, I've faced this on a number of occasions. There have been times when we've been called upon to vote on legislation literally at the midnight hour, sometimes much later than that we haven't seen until moments before it was voted on. There have been other times, and I kid you not, when I've been asked to vote on a piece of legislation that has an annex to it, and I've told that I can't see the annex to the legislation because it's classified, and it's classified in a way that I don't have access to because of a committee assignment that I do not have. It's incredibly frustrating. In those circumstances, we look for a demon. There are demons in those circumstances. They are too numerous to name here. In this circumstance, there is a demon, but that demon is a law of our own creation. It's called the Presidential Records Act. That's the demon that you're after here. That is the only reason we've got this issue. Now, the custodian of those documents holds and exercises a privilege on behalf of the Bush administration. These are documents we would otherwise not have access to because they are privileged. Pursuant to an agreement with the Senate, as an accommodation to the Senate, the custodian of those records has agreed, notwithstanding the privileged nature of those documents, to hand them over to us with an understanding that when there is a need that arises with respect to one or more of those documents to make them public, we can, as a committee, go through a process to do that. That is exactly what has happened. It's what has worked, and it's what has worked here today. So if you're frustrated with the process, then let's review the Presidential Records Act. But we're just doing what the law allows us here to do. These documents are not ours. They belong to someone else. It is not written into the Constitution. It's not written on stone tablets anywhere that we're entitled to documents that don't belong to us. It's significant that William Howard Taft didn't release his presidential papers. It's significant that Robert Jackson, having served as Attorney General, didn't release all the papers he had as Attorney General. Why? Well, I assume it had a lot to do with the fact that they didn't belong to us as a Senate. If we want to be able to have a process, not just with this administration, but in every presidential administration, Democratic, Republican, or of any other stripe in the future, we need to respect the process and respect the privilege that is accorded to documents that do not belong to us. That's all we're asking. And the process is working. Let's move forward.
Mr. Chairman,
Yeah.
on behalf of this side, I would like to just say a couple of things. There is no process for the committee confidential. It used to be that both sides had to concur, the chair and the ranking member. But now this is just simply not the case. To some extent, with this kind of thing, committee confidential becomes a kind of a crock, and it shouldn't. I think we need to sit down. I think we need to have a rule on how committee confidential is determined, on what it means, and who makes that decision. For all I know, some Republican staffer could have made the decision, and I just don't know. Documents appear Our side had nothing whatsoever to do with the designation of committee confidential. So it becomes a way, if there's no rule, for the majority to essentially put all information through a strainer. Should we let this go out and be public, or should we not? And I don't think that's what this committee is about.
Mr. Chairman?
Well, in the absence of a majority of a committee opposed, the chairman acts on behalf of the committee, and Chairman Leahy accepted documents on a committee confidential basis during Justice Kagan's nomination, and there's no indication that the ranking member agreed to that at that particular time. Senator Coons.
Thank you, Mr. Chairman. Just two quick points, if I could. First, the question's been raised, whose documents are these? These are the American people's documents. The Presidential Records Act gives us a right to obtain them for a Supreme Court nomination after the review of the professionals at the National Archives. And Bill Burke is not a professional at the National Archives. The Archives has said that this is not their process. Equally importantly, because some will now make dire predictions about the appropriateness of the release of any of these documents, Bill Burke himself, in his letter to us of August 31st, said, and I quote, that Presidential Records Act Exemption 1, which protects against the disclosure of classified information, did not apply to any documents our team reviewed. I agree with Senator Booker. This confirmation is too important for us to conceal documents that may reveal the nominee's views, and I think we shouldn't be proceeding under these grounds.
Mr. Chairman? May be recognized, sir?
I hope you don't say the same thing again.
Sir, I will not. And first of all, I will say something that I haven't said, which is I appreciate the patience of Job that you're showing here. And I just also want to say to the representations from Senator Kennedy and Senator Lee were right on point, right on correct. They stood strong last night, challenged me, but they not only were collegial, but they looked to find a fair way to deal with this process, and I want to express my appreciation. I want to clarify something that I said before. There is no Senate rule that accounts for this process, period. This is not a Senate rule. I did not violate a Senate rule. But I will pause. I will pause. There is no Senate rule that I violated, because there's no Senate rule that accounts for this process. And I say to a chairman that I respect, that I believe has been fair and good to me, I will say that I did willingly violate the chair's rule on the committee confidential process. I take full responsibility for violating that, sir. And I violate it because I sincerely believe that the public deserves to know this nominee's record. In this particular case, his record on issues of race and the law. And I could not understand, and I violated this rule knowingly, why these issues should be withheld from the public. Now, I appreciate the comments of my colleagues. This is about the closest I'll probably ever have in my life to an I am Spartacus moment. My colleagues, numerous of them, said that they too accept the responsibility. There were very serious charges that were made against me by my colleague from Texas. I don't know if they were political bluster or sincere feelings. If what he said was sincere, there actually are Senate rules governing the behavior of senators. If he feels that I, and now my fellow colleagues who are with me, have violated those rules, if he is not a tempest in a teapot, but sincerely believes that, then bring the charges. Go through the Senate process to take on somebody that you said is unbecoming to be a senator. Let's go through that process, because I think the public should understand that at a moment that somebody's up for a lifetime appointment, that this issue, does the public have a right to know? This is not about the Presidential Records Act. This is not a violation of the Presidential Records Act, not a violation of Senate rules, sir. But if somebody's going to land those charges, I hope that they will follow through with me and Senator Durbin, Senator Coons, Senator Whitehouse, Senator Hirono, Senator Blumenthal, now Senator Feinstein. I hope that they will bring charges against us. And I'm ready to accept the full responsibility for what I have done, the consequences for what I have done, and I stand by the public's right to have access to this document and know this nominee's views on issues that are so profoundly important, like race in the law, torture, and other issues. Thank you.
Mr. Chairman, may I read the Senate Rule 29.5, the standing rules of the Senate for the benefit of all senators? Any senator, officer, or employee of the Senate who shall disclose the secret or confidential business or proceedings of the Senate, including the business and proceedings of the committees, subcommittees, and offices of the Senate, shall be liable, if a senator, to suffer expulsion from the body, and if an officer or employee to dismissal from the service of the Senate and to punishment or contempt. So I would correct the senator's statement. There is no rule. There is clearly a rule that applies.
Then apply the
Mr.
rule
Chairman.
and bring the charges.
Mr. Chairman, all of us are ready to face that rule on the bogus designation of committee confidential. Just because there is a Senate rule doesn't mean it can be misapplied or misconstrued or misused. And I think even the threat raised by one of my colleagues here is unfortunate. And that is a kind way of putting it, with all due respect. And I would just make one other point. We're dealing here with a lifetime appointment. Nothing we do here is more serious than confirming a justice on the United States Supreme Court. Let the American people appreciate that we are here in the most solemn responsibility we have under the Constitution. We need the full truth. Just as this nominee is sworn to give it to us, we are entitled to it from our colleagues. And the question is, what are they concealing by this procedure? What are they afraid the American people will see? What are they afraid we would be asking of this nominee if we had all of those documents that have been denied us in this sham and charade?
Senator Lee, and then Senator Tillis.
To Senator Booker's point, the document you're talking about has now been approved through the committee processes. It's been made public. The process worked. And I pledge to work with each and every one of you. If you got a document as to which a privilege has been asserted such that it's not public yet, I'll work with you to try to make it public. Let's do it. I think we can do this. It's not that difficult. We've done it several times, at least 3 times now. We can do it more. The privilege thing is real, though, and this is not our privilege we're dealing with. This is the privilege that belongs to somebody else. And the privileged nature of documents has been around for a long time, since the early days of the Republic. The records, the notes of the Constitutional Convention were ordered sealed for 30 years after the Constitutional Convention occurred in 1787. I'm not sure all the reasons why, but those who participated in it decided that that was going to be the rule. Sealed 30 years. Those documents didn't belong to anyone else. They belonged to those who attended that convention and participated in it. Now, there were at least 2 from that list, Oliver Ellsworth and James Wilson, I believe, who were subsequently nominated to serve on the United States Supreme Court. No one demanded, to my knowledge, and no one could have gotten, notwithstanding the 30-year seal agreement, the notes to the Constitutional Convention, even though those certainly would have been probative as to how those people might have served on the Supreme Court. And yet no one was accusing the United States Senate back then of being a rubber stamp for the Washington administration or anyone else. In fact, in 1795, the United States Senate disapproved of at least one of President Washington's Supreme Court nominees. This was no rubber stamp. And yet they respected the fact that they didn't own every document, that other people might own them. We don't own these, and so we have to go through the process, a process ordained by a law that we passed and that only we have the power to change. Let's follow that law. We can follow the law and respect the process and respect the rights of each of our colleagues and the rights of the American people to review documents that might be relevant here. But let's go through the appropriate process to do it.
Mr. Chairman,
I think I ought to be fair to the
I
Republicans.
think you should too.
Okay. Go ahead, Senator Tillis.
Thank you, Mr. Chair. Mr. Chairman, I took nearly 17 years to get my college degree. I went to 5 different institutions. I'm pretty sure none of them have been elevated to the Ivy League. That's right. I don't ever plan on running for president in 2020 or any point in the future. I want to make one more comment and then one request. The comment is, I hope everybody will record a transcript of what's going on right now. Senator Lee explains things, I think, in eloquent legal terms, but let's talk about the consequences of making this an untrusted body to receive documents under the Presidential Records Act. You may rue the day that you do that, because you'll probably get fewer documents in the future. Now, what I would like to do is ask all of my members is perhaps we can actually demonstrate to the American people that we're prepared to expose our own records. I would like to suggest, for the purposes of the SCOTUS nomination, that all of us waive any right to the speech and debate clause, and that we allow all of our email records related to the SCOTUS nomination to be made public on an immediate basis. I, for one, am ready to sign up for it now. I hope all my other members would do the same thing, because in the interest of transparency, certainly it would make sense for every one of us, regardless of what we want to do in the future, to expose that information to the American people.
Are you done? I'll start with my questioning. By the way, we're going to have to protect so everybody gets an opportunity to look at the FBI and anything else you want to ask at 1 o'clock. We're going to have to go into executive session and get that done before, if the Senate does close down at 2 o'clock. I mean, if they don't give us permission to meet after 2 o'clock, we've got to get that out of the way. So we'll do that at 1 o'clock.
May I just put a document in the
Would you yield to a
record?
question?
Yeah.
Mr. Chairman,
Yeah.
would you yield to a question about procedure?
Closed, not executive.
I used the wrong word, closed. We're talking about closed instead of executive session. So
Would you yield to a question about procedure, Mr. Chairman?
go ahead.
Could you explain to me why we're having to truncate the hearing today?
Well, I'm not sure we do have to truncate it, but just in case, well, it would be because the minority may object to the unanimous consent request the leader would make for this committee to continue to work while the Senate is in session.
Well, let me be sure I understand. Senator Schumer is saying that we have to shut down while the Senate is in session. Do we not generally waive that rule?
Yeah, generally it is waived, but if it's objected to, we can't meet. So that means that we want to make sure that we get the executive or the closed session out of the way.
Well, may I ask why Senator Schumer is doing that?
Has he done it?
I don't know.
We have a nominee to the Supreme Court of the United States. We've all talked about transparency. What is his basis for doing that?
You'll have to ask him. I don't know.
Mr.,
Yeah,
if I may, I would just like to put a document in the record that the committee was told that President Trump has decided to withhold 102 pages of Kavanaugh's White House counsel records. 102,000. What did I say?
102. You were close.
Thank you. 102,000 pages of Kavanaugh's White House counsel records, and asserted a new claim of constitutional privilege, and of course that hasn't been done before. I'm told there's no such privilege. There's an executive privilege, which is outlined in the Presidential Records Act and requires the president to notify Congress and the archivist, which was not done here. There's a little bit more to it, but I'd just like to put this in the record.
Without objection,
Thank
that
you.
will be put in the record. Yeah. Judge Kavanaugh, we've heard a lot yesterday about your record of independence and impartiality, and you've done more than talk about your independence and impartiality. You've demonstrated the judicial values of the bench. By my account, you ruled against executive branch agencies 23 times between May 2006, January 2009. Of course, President Bush was nominated, who nominated you to the bench, was the head of the executive branch. You had no problems ruling against the president who appointed you, if that's what the law required. And I have no doubt that you'd do the same on the Supreme Court if that's what the law required. You've demonstrated your impartiality. Some of my colleagues tried to depict you as hostile to the little guy and always willing to rule for the powerful. but your record shows that you rule for the party that has the law on their side. So that makes you out to be not a pro-plaintiff judge or pro-defendant judge, but to be a pro-law judge. So let me ask you about a few of your cases that I think demonstrate that you will vindicate the rights of those who are less powerful in our society. After all, our aspirations as Americans is equal justice under the law. So I'll ask you to on each one of them, but just so you know, the three cases I'm thinking about is Rosello, Essex Insurance, and United Food and Commercial Workers. So in the first one, the case in which you ruled for the women wrongfully denied Social Security benefits, tell us your approach to that case.
This case, Mr. Chairman, was a case in which the Social Security Administration had denied benefits. It was a case where the Social Security Administration had denied benefits to a woman who had a history of mental illness, and they had done so because at one point in time she had been employed for a brief period of time with a family member, but it had been subsidized. And this was, in my view, the height of arbitrary agency decision-making. The case had gone on for 15 years, was kind of a hall of mirrors for the woman, and I wrote an opinion reversing the denial of benefits for the woman and also making clear to the Social Security Administration that any further delay would not be tolerated and that these kinds of delays in denying benefits to people with mental illness were unacceptable.
Let's go to the Essex Insurance Company case. Essex Insurance.
In the Essex case, it was a case of a child's family and an insurance company, and the child had been the victim of sexual abuse and on 3 occasions, and the insurance company was trying to pay out simply $100,000 for the total number of for the abuse. And the insurance policy said $100,000 for each occurrence, in essence. And we ruled that the insurance company had to pay $100,000 for each occurrence, each incident of the abuse, and therefore a total of $300,000. So in that case, we were ruled, and I wrote for a victim of abuse against an insurance company that was seeking to squeeze the benefits that were paid under a policy that was owed to the plaintiff in the case.
Okay, then the last one would be United Food and Commercial Workers.
And that's a case, a union case against Walmart, and the case came from the NLRB, and the question was whether Walmart had engaged in unfair labor practices against a union in that case. And in that case, we ruled for the union against Walmart in that case on the ground that the factual record supported the conclusion that the company had engaged in unfair labor practices and therefore violated the rights of the union members.
Yeah. Now to something that I believe I've discussed with every nominee to the Supreme Court probably for the last 15 years. It's not about a case or your approach to the law, and it's something that Senator Kennedy talked to you about yesterday. It isn't a very popular subject with some of the current and former justices. I think I make Chief Justice Roberts uncomfortable when I raise the issue with him when I speak for a short period of time at the Judicial Conference. And then there was a former, when Justice Souter was on the Supreme Court, he made a famous quip about television cameras that they'd have to roll over his dead body. I can respect that view. I just think it's plain wrong. I and many of my colleagues on this committee believe that allowing cameras in the federal courthouse would open the courts to the public and bring about a better understanding of the court and its work. You may be aware of that for a number of years I've sponsored a bill, the Sunshine in the Courtroom Act, which gives judges the discretion to allow media coverage of federal court proceedings. Would you keep an open mind on cameras in the courtroom, or if you have strongly held views on it, don't be afraid to tell me.
Mr. Chairman, I appreciate your longstanding interest in the issue and transparency for the courts, of course. And I'll tell you what we've done on my court briefly, and then tell you some general thoughts going forward if I were to be confirmed. On our court, we've gone from audio release at some date much later. Then we went to audio release same week. Then we went to audio release same day, and now we are allowing audio to go out live with the oral arguments. And that process has been one in which the judges have learned, experienced, and become comfortable with the additional transparency that's become in the same time audio over time, and that process has worked well in our court. On the Supreme Court, I think the best approach for me is to listen to the views of people like yourself, Mr. Chairman, and others I know who are interested in that, to learn, if I were to be confirmed, from the experience there and to see what the experience there is like, to listen to the justices currently on the Supreme Court, as I've said, be part of a team of 9. Well, I'd want to learn from the other justices what they think about this, because several of them, as you know well, Mr. Chairman, when they are in my seat, expressed support for the idea of cameras for oral arguments, and then when they were there for a few years, switched their position after experiencing it. So I'd want to talk to them why that position. And as I said to Senator Kennedy last night, too, I'd want to think about the difference between oral argument and the actual announcements of the decisions. I think those are two distinct things. There hasn't been much focus on the possibility of live audio, for example, of the decision announcements or video of the decision announcements. And I think that's a distinct issue from oral arguments, and I'd be interested in thinking about that and talking to my colleagues if I were to be confirmed. I will have an open mind on it, and I do think when you attend oral argument at the Supreme Court, as I have many times, or you attend the announcement of decisions, it is extraordinarily impressive to walk into that building and the majesty of that building. The building itself conveys the stability and majesty of the law, and to go into the courtroom and to see the justices working together as they do to try to resolve cases is extraordinarily impressive. It makes you confident, I believe, in the impartial rule of law and in each member of the Supreme Court to see them in action. And so I do understand your point of view on this, and I would certainly keep an open mind on it and listen to you and listen to the other justices on the court, of course.
Thank you, Mr. Chairman. I'm going to go back to Roe because most of us look at you as the deciding vote. And I asked yesterday if your views on Roe have changed since you were in the White House. You said something to the effect that you didn't know what I meant. And we have an email that was previously marked confidential but is now public, and shows that you asked about making edits to an op-ed that read the following, and I quote, "First of all, it is widely understood, accepted by legal scholars across the board, that Roe v. Wade and its progeny are the settled law of the land," end quote. You responded by saying, and I quote, "I'm not sure that all legal scholars refer to Roe as a settled law of the land at the Supreme Court level, since court can always overrule its precedent, and 3 current justices on the court would do so. This has been viewed as you saying that you don't think Roe is settled. I recognize the word said, it's what legal scholars refer to. So please, once again, tell us why you believe Roe is settled law. And if you could, do you believe it is correctly settled?
So, thank you, Senator Feinstein. In that draft letter, it was referring to the views of legal scholars, and I think my comment in the email is that might be overstating the position of legal scholars, and so it wasn't a technically accurate description in the letter of what legal scholars thought. At that time, I believe Chief Justice Rehnquist and Justice Scalia were still on the court at that time, but the broader point was simply that I think it was overstating something about legal scholars, and I'm always concerned with accuracy, and I thought that was not quite accurate description of all legal scholars, because it referred to all. To your point, your broader point, Roe v. Wade is an important precedent of the Supreme Court. It's been reaffirmed many times. It was reaffirmed in Planned Parenthood versus Casey in 1992 when the court specifically considered whether to reaffirm it or whether to overturn it. In that case, in great detail, the three-justice opinion of Justice Kennedy, Justice Souter, and Justice O'Connor went through all the factors, the stare decisis factors, analyzed those, and decided to reaffirm Roe. That makes Casey precedent on precedent. It's been relied on. Casey itself has been cited as authority in subsequent cases such as Glucksberg and other cases. So that precedent on precedent is quite important as you think about stare decisis in this context. A similar analogy, the United States versus Dickerson case in 2000, where the court considered whether to overturn Miranda versus Arizona or to reaffirm it. And in that case, the court, through Chief Justice Rehnquist, specifically reaffirmed Miranda, despite the fact that Chief Justice Rehnquist had been a critic of Miranda in his early days and had written some opinions quite critical of it. It became that, so that Dickerson case is similarly precedent on precedent, which is important going forward as you think about the stare decisis calculation for a case like Miranda. So that's why both of those cases, Planned Parenthood versus Casey and Dickerson, are cases where I would refer to them as precedent on precedent.
So you believe it's correctly settled, but is it correct law in your view?
Senator, there's on that case or on Dickerson or on cases like Citizens United or Heller or United States versus Lopez or Kelo, just the whole body of modern Supreme Court case law, I have to follow what the nominees who've been in this seat before have done.
Judge, a yes or a no will do.
Well, I'm just if I can briefly explain.
Yes, you can.
Briefly, I'll try to be brief. But when you're in this seat, I'm not just sitting here for myself. I'm sitting here as a representative of the judiciary and the obligation to preserve the independence of the judiciary, which I know you care deeply about. And so one of the things I've done is studied very carefully what nominees have done in the past, what I've referred to as nominee precedent. And Justice Ginsburg, but really all the justices, have not given hints or forecasts or previews. And Justice Kagan, I think, captured it well, as she often does, in talking about questions like the one you're asking. You can't give a thumbs up or thumbs down and maintain the independence of the judiciary. So I need to follow that nominee precedent here.
Okay. Mr. Chairman, could I ask that the email at issue be made part of the record?
Pardon me?
I'd like to ask that the email at issue be made part of the record.
Yeah, we'll be happy to do that. Thank you. During your time in the Bush White House, the administration actively took steps to limit women's reproductive choices. This included reimposing the global gag rule to prevent foreign organizations from spending their own money on reproductive health, and trying to prevent the FDA from making Plan B contraception available over the counter. During your service at the White House, 2001 to 2006, did you work on any issues related to women's reproductive health or choice?
President Bush was a pro-life president. And so his policy was pro-life, and those who worked for him, therefore, had to assist him, of course, in pursuing those policies, whether they're regulatory. There was partial birth legislation that was passed as well. And some of those things might have crossed my desk. I can't remember specifics, but I think this came up in Justice Kagan's when she worked for President Clinton. He had a different view than President Bush on that issue, and she had some work for President Clinton. I consider myself working for President Bush, was there to assist him.
Let me go to torture. During the time you worked in the White House, the Office of Legal Counsel concluded that harsh interrogation techniques were legal, even though Congress had passed a law in '94 banning torture. The Office of Legal Counsel took a sweeping view of presidential power and concluded that the president could override the statute. In response, in 2005, the Congress adopted an amendment championed by our colleague, Senator McCain. I was the co-sponsor, that stated that only interrogation techniques that can be used are those authorized in the Army Field Manual. Was the Office of Legal Counsel correct when it concluded that the president could ignore the torture ban?
So the Office of Legal Counsel, Senator, subsequently withdrew those memos, as you know. And as I've made clear in some of my writings, the review of Judge David Barron's book, some of my opinions as well, the president does not have the authority to disregard statutes passed by Congress regulating the war effort, except in certain very narrowly described circumstances that are historically rooted, the common example being command of troops in battle. So as a general proposition, the president has to comply with the law. The president is subject to the law, including in the national security context. That is the lesson, I think, of the Youngstown Steel case of Justice Jackson's categories. Category 3, as I've said repeatedly in my writings, which is where Congress has prohibited the president from doing something, is critically important. That's essential to the rule of law, as Justice Jackson said. That's the equilibrium of the country is at stake in Category 3, and I've written about that quite frequently.
Got it. Thank you. Today we have a president who said he could authorize worse than waterboarding. How would you feel about that?
Senator, I'm not going to comment on, and don't think I can, sitting here on current events.
Well, but you know what the law is. You've made that clear.
I know what the law is, Senator,
So
and I know you're...
I asked specifically, how do you feel about that?
I feel that I should follow the law as a judge. I know what the law is, and I know your leadership on this issue, both with the report you did, which was the thorough documentation of things that happened, as well as recommendations for the future. And I know your leadership with Senator McCain on the 2005 Act as well. And I know what the law is, and I've written about how the separation of powers works when Congress passes laws of the kind that you have.
One last question on this. In December of '05, President Bush issued a signing statement regarding the Detainee Treatment Act of 2005, reserving the president's right to disregard the law's ban on torture if it interfered with his constitutional authorities as president. What was your involvement, if any, with this signing statement?
While I was staff secretary, any issue that reached the president's desk, with the exception of a few covert matters, would have crossed my desk on the way to the president's desk. I wouldn't have, in the ordinary course, provided the policy advice or the legal advice, but it would have crossed my desk. So in that case, the signing statement, the drafts of it, that process would have crossed my desk at some point.
Okay. In a 2013 panel discussion, you did nothing about it, though. It crossed your desk, and that was that.
Well, there was debate, as I think I've mentioned, about that. The counsel to the president, Ms. Myers at the time, was the ultimate advisor on that matter for the president, and thus would have been the one who primarily dealt with that with the president. It was important as in the job I had there not to supplant the policy or legal advisors. That was not my job. My job was to make sure the president had the benefit of the views of his policy and legal advisors.
One more Bush-era question on this. In a 2000 panel discussion at NYU Law School regarding Bush administration anti-terrorism policies, you said the Bush administration went, quote, right up to that legal line to defend the security of the United States, end quote, implying that Bush policies did not cross the legal line. Do you mean to suggest that Bush administration's post-9/11 programs, including the CIA torture program, were legal?
No, Senator, that's not what I was suggesting there, and let me try to provide you an explanation. President Bush's view, as I think he has said publicly, was in trying to keep America safe, he was going to do everything he could within the law. He relied on his lawyers to provide him the boundaries of what the law is, and then he would go up to that line as he thought effective as a matter of policy. It was up to the lawyers, therefore, to make sure that they were giving sound advice and having the backbone, and this is something that your legislation reinforces. Lawyers need to have backbone, even in pressurized moments, to say no. And I've talked about that many times. One of the most important responsibilities of an executive branch lawyer in the passions of the moment, where the pressure's on, where the president wants to do something perhaps, is to go into the Oval Office and say, no, you shouldn't do this. And that's something that I've written about, talked about, and experienced in my time with President Bush. And I've encouraged young lawyers to have that backbone and fortitude to say no. That's about the most important thing.
Thank you. A quick change of subject. You sat on a case where a trainer, Dawn Brancho, was killed while interacting with a killer whale during a live performance. Following her death, the Occupational Safety and Health Administration found that SeaWorld had violated workforce safety laws. The majority agreed with the agency that SeaWorld had violated the law. According to what I know, you disagreed. In your dissent, you argued that the agency lacked the authority to regulate employers to protect participants in sporting events or entertainment shows. However, the statute, as enacted, applies to each employer, and it defined employer as anyone engaged in business affecting commerce who has employees. Where in the text of the law did Congress exempt employers of animal trainers?
Thank you for the question, Senator. The first point I want to make is that was not a case that involves potential compensation to the family. That was handled through the state tort system or through insurance or through a settlement with the SeaWorld and the family. So the case before us had nothing to do with compensation to the family. It had to do with a separate regulation of SeaWorld. The issue, Senator, was precedent. I follow, as a judge, I follow precedent. The precedent of the Labor Department, as I read it, was that the Labor Department under the statute would not regulate what it called the intrinsic qualities of a sports or entertainment show. So lots of sports and entertainment shows have serious dangers, whether it's football or the balance beam in gymnastics or the high wire act at the circus or the lion tamer show. And the SeaWorld show was, of, as I saw it, of a piece under those with that precedent that said the Labor Department would not regulate, for example, whether baseball helmets had to have ear flaps or whether to prohibit the punt return or to make the balance beam have nets. And this seemed to be covered by that precedent as I saw it. The Labor Department in the oral arguments tried to distinguish, for example, the dangers of football from the dangers of the SeaWorld show, and I did not, as I explained in the opinion, find that distinction persuasive. But I did make clear two things, Senator. One is Congress could, of course, regulate the intrinsic, Congress could make the decision to regulate the intrinsic qualities of sports and entertainment shows, or the Labor Department could change its precedent. And I made clear that, of course, state tort law, as the NFL has experienced with the concussion issue, state tort law always exists as a way to ensure or help ensure safety in things like the SeaWorld show.
Thank you. A question, if I may, about independent agencies. Congress has established several independent agencies. We believe they're essential to enforcing our laws and safeguarding consumers. Congress requires the president to have good cause to remove the heads of these agencies to insulate them from political interference. You have objected to this limit on the president's power and struck down the for-cause requirement in a case involving the Consumer Financial Protection Bureau. The D.C. Circuit disagreed and overturned your decision. If the president can fire the heads of independent agencies for any reason, what's to prevent political interference in these independent agencies?
Senator, I have followed the Humphreys executor precedent. I've referred to it as entrenched. That is the precedent that allows independent agencies and protects them from at-will firing, the for-cause restriction. So as a general matter, I have affirmed I've followed the precedent of Humphreys executor. The example you're talking about, the Congress established a new independent agency that did not follow the traditional model of independent agencies of having multiple members. That's all I thought was problematic there, and I did not invalidate or did not say the agency should stop operating. I said the agency can continue performing its important functions on behalf of consumers, but either it had to be restructured as a multi-member agency or the president had to be able to remove the single head at will.
The limited set of documents we've received indicates that you were heavily involved in the Bush White House's response to congressional investigations after the Enron scandal. Is that accurate?
That is accurate. We had a document request from Senator Lieberman's committee, and I was one of the lawyers that had to help gather the documents from people within the White House and then had to negotiate documents. I had to negotiate documents with Senator Lieberman's staff.
Right. So you know that Enron was one of the greatest corporate scandals in American history. And I can tell you as a senator from California, not only did many of my constituents lose everything financially when Enron collapsed under the weight of its accounting fraud, but the fraud and market manipulation contributed to an energy crisis in California. White House emails show that you were asked to review a set of draft talking points for Press Secretary Ari Fleischer that address the role of Enron's market manipulation in the California energy crisis. Essentially, the talking point said if there was any misconduct by Enron, it was up to the Federal Energy Regulatory Commission to investigate and punish the company. I'm not going to ask you if you remember this specific document, but was that your view that FERC was the regulatory body that was supposed to stop this sort of misconduct?
I'm not recalling the specifics of that, Senator. My role as a general matter was to help gather documents in response to Senator Lieberman's committee's requests, as I recall. And I know FERC would have a role necessarily in something like that, but I don't know if I thought primary or I don't think that was my area of expertise, so I'm just not recalling it specifically, Senator.
Yeah.
Sir, have you conscience, Honorable Judge Brett, who stand only by the death of the Republic?
Senator Hatch.
Thank you, Mr. Chairman. Thank you.
Senator Hatch.
Well, thank you, Mr. Chairman. I appreciate the way you've conducted these hearings, and in spite of these type of irresponsible outbursts and so forth, it's hard to believe. Now, Judge Kavanaugh, I'd first like to commend you for how you've conducted yourself these last 2 days. You have displayed the level-headedness and decency that so many of your friends tell us actually exist. And I would say your friends and foreign colleagues have described in their letters to this committee I wish I could say the same about everyone who's attended this hearing or conveyed it or covered it on social media, but I can't. I'm deeply concerned about the theatrics we've seen these last 2 days. I've been on this committee for 42 years, longer than any other person except Senator Leahy. I'm the former chairman. Never have I seen the constant interruptions we witness at this hearing. Confirmation hearings are supposed to be an opportunity for the American people to hear from the nominee. Unfortunately, it seems that some on the political left have decided to try to turn this hearing into a circus. Now, I worry about the precedent this is setting for future confirmations, but that's not the worst. Now, the worst of it are the attacks against people who aren't even up for confirmation, who just happen to be here in the room to support the nominee. It's bad enough that Supreme Court nominations have turned into all-out war against the nominee. Have we really reached a point where anyone who supports or even sits behind a nominee must also be destroyed? Has our tribalism really reached that low? To those who have been unfairly caught up in the mob mentality of the last 2 days, I just want to say, you're right to be here, supporting someone you believe in. Don't let the fact that there are a lot of, frankly, sick people out there cause you to lose faith in our political process. We need good, decent people to step forward to contribute even when it's ugly, particularly when it's ugly. Just now to my questions. Let me ask you this. As I did yesterday, I'd like to ask you to keep your answers to my questions concise so we can get through as many of them as we can. Late last night, one of my colleagues asked you a series of open-ended questions about any conversations you have had with anyone at a 350-person law firm about Special Counsel Bob Mueller or his investigation. You said you do not remember having had any such conversations. My colleague did not clarify why my colleague was asking the questions and did not allow you to complete your answers. I want to give you a chance to respond if you'd like to.
Sure, Senator. I don't recall any conversations of that kind with anyone at that law firm. I didn't know everyone who might work at that law firm, but I haven't had, don't recall any conversations of that kind. I haven't had any inappropriate conversations about that investigation with anyone. I've never given anyone any hints, forecasts, previews, winks, nothing about my view as a judge or how I would rule as a judge on that or anything related to that. So I thank you for the opportunity to clarify and reassure you on that.
Well, thank you. With all of the accusations and insinuations and innuendo being hurled around yesterday, there's something I have to come clean about. I'm on the board of visitors of the Federalist Society. It's true. For those who are not familiar with the Federalist Society, it generally holds debates and puts together panels on legal issues covering all sides of these issues, the liberal, the conservative, et cetera. It's a very responsible organization. The American Constitution Society, the Democrat organization, does much the same thing, and I respect them, except it focuses on liberal or progressive lawyers. So this is familiar to my Democratic colleagues on this committee. They've been involved with ACS's, with the ACS from keynoting the annual conference to being an honorary host committee chair, to speaking on panels, to writing blog entries for the organization. I even heard a nasty rumor that one of them spoke at a Federalist Society event. Can you believe that? You've already said that when it came to your nomination, you spoke with the president, the vice president, and the White House counsel, Don McGahn, not the Federalist Society. So I don't need to ask you about that. My question for you is this. What has your experience with the Federalist Society been?
Senator, thank you. The Federalist Society, as you note, provides, holds debates at law schools.
On both sides.
On both sides. The typical program of a Federalist Society event at a law school will have 2 speakers and a moderator. That's typical, with the 2 speakers presenting different views on an issue. It could be, for example, Fourth Amendment privacy, where you have someone who's got different view on national security-related Fourth Amendment issues or on free speech issues or all sorts of legal issues. They try to have debates where both sides are presented at the law school events that I've been to. At the conventions, they'll always have panels of 4 or 5 with a moderator where they'll have a spectrum of views represented on a different topic. They're very enriching in terms of your knowledge of the law, and they're also enriching, I believe, in terms of providing different perspectives on the law, and they welcome people and actually insist on having people from all different perspectives at the event. So it is very beneficial to the law. I think the programs they have at the law schools, they're very educational. They provide some of the best debates that are held at the law schools, I believe. And so I think the organization, which itself does not lobby and does not file amicus briefs or anything like that, does a very valuable service at law schools and the legal community as a whole for bringing together different views on important legal issues. And I applaud them for their efforts to bring speakers to campus and provide legal debates on campus and in lawyers' conventions.
You've described it quite well. Earlier this year, I attended oral argument in Microsoft versus United States, also known as the Microsoft Ireland case. Naturally, I was very interested in that. At issue in the case was the meaning of the Stored Communications Act and whether a warrant for data stored overseas but accessible in the United States falls within the Act's confines. I had introduced legislation known as the Cloud Act to resolve this issue. Following oral argument, Congress passed the Cloud Act, thus mooting the case before the court. Now, the specific question at issue in the Microsoft Ireland case has been resolved by my legislation, but the case also raised a broader question that I'd like to ask you. When the Stored Communications Act was passed in 1986, no one imagined a world where data could be stored overseas but accessible instantaneously in the United States. It was clear that the Act covered data stored in the United States, but it was less clear that it extended to data stored abroad using new technologies that were not available in 1986. How do we interpret our laws in light of changing technology? How do we determine whether the authors and enactors of legislation would have intended the legislation to cover new technologies and unforeseen situations?
Senator, I think there, as elsewhere, the job of a judge is to focus on the words written in the statute passed by Congress. Sometimes Congress will write a statute where the words are very precise and it's quite clear it covers only something that might be in existence at the time. Sometimes Congress will write broader, more capacious words, as does the Constitution at times, that can apply to new technologies. For example, the Fourth Amendment, of course, in the Constitution applies to things that were not known at the founding, including cars and communication devices that were not known at the founding. So too with statutes, it depends on how broadly or narrowly you've written it. And your question raises a broader point, which is the issue of privacy and liberty on the one hand versus security, law enforcement on the other, is an enormous issue going forward for the Congress in the first instance, I believe, and also for the federal courts, including the Supreme Court going forward. The Carpenter case this past term is a good example of that, written by Chief Justice Roberts. Right. And as I look ahead over the next 10 to 20 years, that balance of Fourth Amendment liberty and privacy versus security and law enforcement is an enormous issue.
Well, I appreciate your elucidation on that. On the domestic front, there's been debate for some time now in Congress about whether our laws should be updated to require a warrant for the content of electronic communications, regardless of how old those communications are. As you may know, the Electronic Communications Privacy Act currently distinguishes between communications that are less than 180 days old and those that are more than 180 days old, requiring a warrant for the former, but not the latter. Can you speak generally to the importance of warrant requirements and why they're an important bulwark against the government overreach?
The warrant requirement helps ensure, as a general matter, that the executive branch is not unilaterally able to invade someone's privacy, someone's liberty without judicial oversight that ensures that there's probable cause or whatever the standard might be in a statutory situation to get someone's records or information or otherwise invade their liberty or privacy. So that judicial oversight is part of the checks and balances of the Constitution, and Congress has written that also into several statutes, as you know, Senator.
Well, I want to return to the email Senator Feinstein was asking you about. You were asked for your comments on an op-ed that was going to be published by a group of pro-choice women in support of a circuit court nominee. You said, quote, "I am not sure that all legal scholars refer to Roe as the settled law of the land at the Supreme Court level, since court can always overrule its precedent," unquote. You then added, quote, the point there is in the inferior court point, unquote. Were you giving your opinion on Roe there, or were you talking about what law scholars might say?
I was talking about what legal scholars might say, and I thought the op-ed should be accurate about what in describing legal scholars.
Okay, so we got that cleared up. Yes. You've been critical of the practice of judges sentencing defendants based on uncharged or acquitted conduct. With regard to acquitted conduct in particular, I agree that the notion that a judge can sentence a defendant to a long prison term for a crime that a jury acquitted the defendant of flies in the face of the right to a jury trial. You've written that you believe, quote, "it likely will take some combination of Congress and the Sentencing Commission to systematically change federal sentencing to preclude use of an acquitted or uncharged conduct," unquote. Why do you take issue with the use of acquitted conduct at sentencing, and why do you believe this is an issue that will likely require intervention by Congress to resolve?
The opinions I've written on this, and I've written several, say, in essence, the following, Senator. When a criminal defendant, for example, let's say is charged with 10 counts, let's suppose, and is acquitted on 9 and convicted on 1, and then the criminal defendant is sentenced as if he or she had been convicted of all 10, because the judge just says, well, I think, you did X or that Y, and under my discretion, which you now have under the Supreme Court's case law for sentencing, I'm just going to sentence you the same anyway. Defendants and the public, the families of the defendants, understandably say that seems unfair. I thought the point of the jury trial was to determine whether I was guilty or not guilty on all those charges. And if I'm getting sentenced exactly as if I were guilty on all the charges, that seems a violation of due process. So I've written about the fairness and perceived fairness of the use of acquitted conduct at sentencing. Judge Millett on my court and I have both written about it several times and made clear our concern about the use of acquitted conduct and how it affects the sentencing system. Why I've said Congress might need to look at it, although I've also pointed out individual district judges can look at it, is because under the current system, sentencing judges have wide discretion in picking sentences, so it's hard for a appeals court to say that you've infringed your discretion given some of the case law of the Supreme Court which grants that discretion. But I don't like the practice, and I've made that clear in my opinions, so I'm just repeating my opinions here because of the unfairness and perceived unfairness of it.
Okay, this committee has been chasing an elusive deal on criminal justice reform for quite some time now. One particular focus of mine in this area has been mens rea reform. Without adequate mens rea protections, that is, without the requirement that a person know his conduct was wrong or unlawful, everyday citizens can be held criminally liable for a conduct that no reasonable person would know was wrong. Critics of my legislative efforts to bring clarity to mens rea requirements claim the effort is a ploy to get corporations and white-collar defendants off the hook. But stronger mens rea requirements protect the liberty of all defendants in the criminal justice system, the vast majority of whom are not corporations or white-collar defendants. You've written about the importance of mens rea requirements, including in cases involving unsympathetic defendants like an armed robber or a convicted murderer. Why, in your view, are mens rea requirements so important?
Mens rea requirements are important, but because, Senator, under the Due Process Clause and the precedents of the Supreme Court, it is not right to convict someone based on a fact they did not know. It's just an elemental point of due process. Justice Jackson described this principle in his famous Morissette decision that he wrote. It's as elementary as he said, as the school child's, I didn't mean to, I didn't know. And if someone truly didn't know a fact that that's relevant to their conviction, to nonetheless convict them is contrary to due process. I've seen cases where a mandatory minimum sentence was elevated from 10 years to 30 years, 30-year mandatory minimum based on a fact that the defendant did not know. I dissented in that case, in an in-bank case, joined by Judge Tatel, who was an appointee of President Clinton to our court, saying that, and I wrote a very lengthy dissent about the history of mens rea and just how much of a violation of due process I thought had occurred in that case. That was not a sympathetic defendant, given what he had been convicted of, but I thought it was a complete violation of due process and principles of mens rea that were longstanding from Morissette to give him a 30-year mandatory minimum for a fact he did not know. I have also joined an opinion and wrote a separate opinion reversing a murder conviction of someone where the jury instructions were unclear about the mental state of the murder. It was a question of manslaughter versus second-degree murder. That would have had a huge difference in the defendant's sentence. And I wrote an opinion saying this was not an especially sympathetic case given the facts, but the jury instructions were flawed on the issue of the mental state. And my exact line was, I'm unwilling to sweep that under the rug. And that's how I felt about that case. There was a dissent in that case, but I was in the majority reversing the murder conviction in that case. No matter who you are in my court, if you have the right argument on the law, I'm going to rule in your favor, and mens rea is foundational to due process. I've written that repeatedly, and I share your concern about mens rea reform, Senator Hatch.
Well, thank you. I have one last question. Some people seem to think that religious people should not work in government because they swear allegiance to their church, not their country necessarily. I have faithfully served in this country for over 40 years, and I believe I'm a religious person. Now, religion is also a big part of your life. You went to Catholic school, your children go to Catholic school, and you regularly attend church and serve at a church-supported soup kitchen. I know that religious faith is a personal subject, but I'd like to hear from you how your private beliefs affect your public decisions. Can you be devout in your faith and still uphold the law?
Senator, my religious beliefs have no relevance to my judging. I judge based on the Constitution and laws of the United States. I take an oath to do that. For 12 years, I've lived up to that oath. At the same time, of course, as you point out, I am religious, and I am a Catholic, and I grew up attending Catholic schools. And the Constitution of the United States foresaw that religious people or people who are not religious are all equally American. As I've said in one of my opinions, the Newdow opinion, no matter what religion you are or no religion at all, we're all equally American. And the Constitution of the United States also says in Article 6, no religious tests shall ever be required as a qualification to any office or public trust under the United States. That was an important provision to have in the founding Constitution to ensure that there was not discrimination against people who had a religion or people who didn't have a religion. It's a foundation of our country. We're all equally American.
Thank you, Mr.
Senator Leahy.
Thank you, Mr. Chairman. And as I mentioned to you earlier, I have a number of letters that ask consent to be placed in the record, as well as the emails that were declassified, I think some at 3 o'clock this morning, that they be placed in the record.
Without objection, so ordered.
Thank you. And I know there was claim this morning the committee was following my precedent, Judge Kavanaugh. Not so. For Justice Kagan, we had 99% of her documents for her time at the White House. And of course, we do not have, we have less than 10% of yours. And there were 860 documents designated as committee confidential by the nonpartisan National Archives. That was discussed with both the Democrats and Republicans on the committee. Nobody objected to that. But let's go to follow up on our questions yesterday. And we discussed the fact that while you worked on nominations in the Bush White House, you received stolen material from a Republican Senate staffer named Manny Miranda. I thought it was a digital Watergate. He stole 4,670 computer files from 6 Democratic senators. He was doing this in an effort to confirm some of President George W. Bush's most controversial judicial nominees. They were some of the most contentious fights of the day, and this Republican stole 4,670 computer files. Now, in 2004 and 2006, you testified. A number of senators, both Republicans and Democrats, asked you, and you said you never received any stolen materials. That doesn't appear to be accurate. You also testified that you knew nothing about this scandal until it was public, and if you had suspected anything untoward, you would have reported it. You also testified to Senator Hatch that you never received any document that even appeared to you to have been drafted or prepared by Democratic staff. I also asked you yesterday whether Mr. Miranda asked to meet privately off-site to hand you documents related to Senators Biden and Feinstein. I also asked about him sending you, quote, intel with extraordinary detailed specifics about what I was going to ask a highly controversial nominee just days later, something I never said publicly. I also asked about you receiving a draft, a non-public letter of mine, before any mention was made public. You testified you didn't recall anything specific, but you thought that the sharing information between staffs was common. So let me ask you this. Has anyone told you what any Democratic senators have been advised to do by our staff at this hearing?
I think there's been a lot of...
Tell the truth!
There's been a lot of discussion about what individual senators might be interested in, and when I met
I really want to hear what you have to say, Judge, not what protesters have to say. Please go ahead. Have you been advised, have you been told what any Democratic senators have been advised to do by our staff at this hearing?
Right. So when I met individually with the 65 senators, including almost every member of the committee, a lot of the senators, a lot of you in the meetings told me issues you were interested in. I think your staff was probably talking to...
No, but has anybody said to you, for example, Senator Leahy's staff is asking him to do this at the hearing tomorrow?
Well, I think you yourself told me what you were going to ask. So
No, I tried to give you a good heads up, and I appreciate the meeting, but has anybody else told you this is what Leahy's staff is asking him to ask at the hearing tomorrow?
Again, I think this might be a different kind of process because you all were very transparent when I met with you. I'm looking around and saying, here's what I'm focused on and here's what I'm going to ask you at the hearings. And it's turned out you were accurately telling me your concerns.
Okay, and you're saying that's normal, but did anybody hand you anything marked highly confidential
for this
about any one of these senators?
Now, I'm not remembering anything like that, but you all did talk about the issues. In other words, there are no surprises. They're not no surprises, but you gave me a basic concerns and issues you wanted to
I want to make
raise.
sure we're clear on this.
Yeah.
Nobody handed you something marked highly confidential, but that is the material you received from Manny Miranda. For example, on July 18, 2002, days before an extremely controversial hearing for Fifth Circuit nominee Priscilla Owen, Mr. Miranda sent you an email with the subject line, highly confidential. Informed you that Senator Biden's staff was asking him not to attend the meeting that day. On March 18th, 2003, Mr. Miranda sent you several pages of talking points that were stolen verbatim from Democratic files. The talking points revealed what arguments Democrats were making on another controversial nominee, Miguel Estrada. The subject line of the email stated it was not for distribution, meaning Mr. Miranda was asking you not to share the information. This has now been, as of 3 o'clock this morning, made public. So yesterday when I asked you about these specific events, you said you didn't have any recollection. So I'm not going to ask if you remember receiving this email. I'm going to ask you this. Why would you ever be asked to keep secret Democratic talking points if they were legitimately obtained?
I am looking at these, Senator, and it says, for example, it looks like Biden's staff is asking him not to attend the hearing. I don't know why that.
But look how you received it.
I know, I don't know why that's even confidential because it.
Whether it is or not, would you consider that somewhat unusual to be receiving from a Republican staff member something marked highly confidential, telling him what he's found out the Democrats going to do?
Well, as I explained yesterday, Senator, my understanding of this process is that the staffs do talk with one another, that they're not camps with no communication. And that was my experience when I worked in the White House. And so it looks like Biden's staff is asking him not to attend the hearing would have been pretty standard kind of information that would be.
Not really. You read this, I would be amazed if somebody handed me a memo saying this is a confidential memo that Senator Grassley's staff has prepared for him. I not only would not read it, I'd be on the phone immediately to Senator Grassley, say, I'm bringing something over that just arrived to me, you better take a look at it. But you received, on July 28, 2002, an email from Manny Miranda that said, my staff distributed a confidential letter to Democratic counsels, not to Republicans. Mr. Miranda said, I received that letter in the strictest confidence. You were asked explicitly by Mr. Miranda to take no action on the email without his further instructions. He never asked him how he obtained the letter sent in strict confidence to me. And then July 30th, 2002, you received an email from Miranda saying they had on 100% info that I was convening a meeting about a controversial nominee. And then further in August 13, 2002, emailing obviously taken from my internal emails, what I was going to do. Did any of this raise a red flag in your mind?
It did not, Senator, because it all seemed consistent with the usual kinds of discussions that happen. And sometimes people do say things of, here's what my boss is thinking, but don't share it around. I mean, I must have had, so many conversations in the course of my life like that, where someone's saying like that about something. In other words, trying to give you a heads up on something. And that just seems standard Senate staff. So nothing, the direct answer to your question is, for example, looks like Biden's staff's not asking him not to attend the hearing. That wouldn't have raised anything at all for me other than
Not even where it came from. On June 5th, 2003, you received an email from a Republican Senate staffer with the subject line, spying. That is not overly subtle. This staffer appears in over 1,000 documents we received together with both you and Mr. Miranda. She says she has a mole for us, and so forth. None of this raised a red flag with you?
It did not, Senator. Again, people have friends across the aisle who they talk to. At least this was my experience back then. Maybe it's changed. And there was a lot of bipartisanship on the committee. There was a lot of bipartisanship among the staffs. There were a lot of friendships and relationships where people would talk to, I've got a friend on Senator Ted Kennedy's staff, or I have a friend on Senator Hatch's staff, or I have a friend on Senator Specter's staff. That kind of conversation and information sharing was common. So it did not raise the flags.
Judge, I was born at night, but not last night. And if I had something that somebody said, we've stolen this, or this is how, don't tell anybody we have this, I think it would raise some red flags. Now, we only have a fraction of your record, and I do thank the chairman for opening us up at 3 this morning. But as you know, the president has asserted executive privilege. The first time we've had to face this up here on a nominee from either Republicans or Democrats, of 102,000 pages of material, 102,000 from just your time in the White House. That includes a lot on judicial nominations. Can you confirm for me today that in that 102,000 pages, there are no emails from Mr. Miranda marked highly confidential or do not share or take no action on this, describing what he has found out the Democrats are thinking?
Senator, I am not involved in the documents process, so I don't know what's in them.
Well, that is convenient. But we don't know what's in them either, because we've never had so much withheld before. We don't know what's in all of the documents. They're still being gone through by the archives because this is being rushed through and we don't get a chance to see them. That's not fair to us, and frankly, Judge, it's not fair to you. You've probably been told you have the votes to be confirmed, so you don't have to care. But I care. I care about the integrity of the Supreme Court. I care about who's on there. I think you should care what's in that, just as we should care what's in it. There are even more documents than I had time to discuss today. I find it impossible to reconcile what you're regularly being told, that your testimony that you received nothing stolen, had no reason to suspect anything was stolen, when, frankly, as we now know, Republican staffer Manny Miranda stole things. And some of the things he stole went directly to you. Let me ask you another one. You testified in 2004 that aside from participating in a moot court argument, you did not work in the nomination of Judge William Pryor. Now, he was a controversial nominee. He called Roe versus Wade the worst abomination in the history of constitutional law. he argued that constitutional right to same-sex intimacy would logically extend to activities like necrophilia, bestiality, pedophilia. You said you didn't work on his nomination personally, but you did participate in the prior working group, did you not?
We all were met, just so you know the process, there was something called the White House, I think, Judicial Selection Committee, and Judge Gonzalez, the counsel to the president, chaired that committee. And that started immediately after President Bush came into office in 2001. And so we would meet with memos, and individual members of the staff would be assigned to different meetings.
Did you interview William Pryor?
I don't believe so. It's possible, but I don't believe so. But if I did, it would have been part of the general process where people came in.
I put in the record, our Exhibit C, which said you did interview him.
It's possible. We interviewed hundreds of nominees, as I said, Senator, and we met every week for several years to go over nominees. And we worked closely with the home state senators. I had various states for district court. I had Illinois. I had California I worked on with Senator Feinstein, Senator Boxer's staff. Maryland, Senator Sarbanes and Senator Mikulski. But then we would sit in sometimes on interviews of other people who came in, and then we would meet and go over the memos. Then we would meet with the president. We met every week with the president before September 11th. After September 11th, those meetings became less frequent.
You had recommended him. You had recommended him internally for the 11th Circuit seat, had you not?
Well, I have no reason that I wouldn't have recommended him, because he was a highly qualified Attorney General of Alabama, and Senator Sessions, of course, knew him well, and he was well respected.
The only reason I asked was that one of the emails that we have up here says, Brett, at your request, I asked Matt to speak with Pryor about his interests. I'm not asking these questions to get you in a bind, Judge. I'm asking them because it is so easy on these hearings to say, I don't remember, and oftentimes that's the case. But you mentioned Mr. Gonzalez. He had difficulty remembering when he came here. He had one hearing where, so that he wouldn't have that problem, I gave him, I think, 35, 45 of the questions ahead of time. On every one of them, he said, I don't remember, I don't recall. And then every question asked, almost every question asked by both Republicans and Democrats, said, I don't recall, I don't remember. Shortly after that, he went to private practice. But I think it is so difficult that you don't remember the things done by somebody who I think on both sides of the aisle we would agree is one of the most egregious breaches of committee confidentiality, when Manny Miranda stole material from here, stole it to send it to you and others at the White House. You have no recollection of that.
I obviously recall the emails, or have seen the emails, but your larger question was, did that raise a red flag? And I've answered that no.
Well, when you were in the White House, was part of your job to coach President Bush's judicial nominees how to answer Democrats' questions about Roe versus Wade?
part of our job would have been to prepare nominees more generally, and it was common for senators to ask that question then as it is now. And so I assume that we would have been involved in going through mock sessions. I know we were involved in going through mock sessions, which is very standard for Democratic.
Well, you've been going through some mock sessions with at least one Republican senator from this committee and other Republican senators, and I'm not saying that is a gotcha thing. You have every right to do that. You did advise Priscilla Owen exactly how she should respond to that according to one of the emails. And my last question, do you agree that a plastic firearm created with a 3D printer, something we would not have been in the minds of our founding fathers at the 18th century, would you agree that that could be regulated or banned without creating any Second Amendment questions?
I think there might be litigation coming on that, Senator, so consistent with judicial independence principles, I shouldn't comment on a potential case like that, so thank you.
I actually written out your answer ahead of time, and I just wrote it so that you did not see what I wrote. Thank you very much, Mr. Chairman.
Senator Graham.
Thank you, Mr. Chairman. I'd like to introduce into the record an op-ed from the LA Times editorial board entitled, "Can the Supreme Court Confirmation Process Ever Be Repaired?" A bipartisan letter from 23 of Judge Kavanaugh's classmates at Yale, a letter signed by hundreds of Yale students, alumni, and faculty, a letter from Georgia's Secretary of State Brian Kemp, an op-ed in the Clarion Ledger by Mississippi Governor Bill Bryant. So I'd ask that that be allowed. Just say without objection. That's good. Okay. All right. Thank you, Judge. There are several things I want to go over with you. One, I want to compliment Senator Lay in this regard, that he worked with Senator Grassley to get what had been previously committee confidential released to the public. And so that's the way it works around here. You don't always get what you want, but you try to work with your colleagues, and many times you can succeed. From a public's point of view, it's got to work this way. You just can't do everything you want in a legislative body. There are rules, and it's frustrating to be told no on something you're passionate about. But I'm often asked, people wonder, are these hearings turning into a circus? And I want to defend circuses. Circuses are entertaining, and you can take your children to them. This hearing is neither entertaining nor appropriate for young people. Now, some of my colleagues, who I respect greatly, are trying to make a point. I don't know what that point is. But I do know this: if you want to be president, which I can understand that, it's hard. And what you do will be the example others will follow. Back to the subject matter, the Morrison case. Was that about separation of powers?
That was a separation of powers case.
Okay. It was about a congressional statute and the authority of the executive branch and how they interacted. Is that correct? That's correct, and a very specific statutory scheme that was unprecedented, had the judiciary involved in appointing the counsel. And apparently, Kagan and Scalia agreed. Yes. Well, but Kagan agreed with Scalia's dissent. She's called it one of the greatest ever written, and she's added it gets better every year. Well, I don't want to get in the habit of saying listen to Elena Kagan, but I will here. Because she's a fine person. The situation we have before us about Mr. Mueller, that's not a separation of powers issue, is it? Aren't these different facts? That Mr. Mueller was appointed through Department of Justice regulations. Senator, I don't want to talk specifically about current events, but I will just refer back to what I've written previously about special counsel. I'm not asking you to how to decide a case. I'm just asking, do you read the paper? Do you watch television? The special counsel statute in question doesn't exist anymore, does it?
The independent counsel statute.
Yeah, independent counsel
Does
statute.
not exist anymore
Okay.
since 1999. The
Okay.
traditional special counsel system I've written about is the ordinary way that outside
But
investigations.
is that an executive branch function?
That is ordinarily appointed by the Attorney General and isn't
Who's a member of what?
the executive branch.
So last time I checked, that's not a separation of powers issue.
That traditionally, as I've written, has been an executive branch.
Now, the question is, if someone's appointed as special counsel by Department of Justice regulations, who has authority over implementing those regulations and overseeing those regulations? All I can say is that that's different legally and factually than the Morrison situation where you had a statute. Let's talk a little bit about the law regarding the president. Clinton v. Jones tells us, see if I'm correct, that you can be president of the United States, you can still be sued for conduct before you were president, and when you invoke executive privilege, the court has said, no, wait a minute, you have to show up at a deposition because it happened before you were president. Is that correct?
Yeah, in a civil suit was the Clinton versus Jones case involving allegations that, or a suit that had involved activity before President Clinton became president.
So it's pretty well understood through Supreme Court precedent that if you're the president of the United States and you engaged in conduct that allowed you to be sued before you got to be president, you can't avoid your day in court and on the civil side. The Nixon holding said what?
The Nixon holding said that in the context of the specific regulations there, that a criminal trial subpoena to the president for information, in that case the tapes, could be enforced, notwithstanding the executive privilege that was recognized in that case as rooted in Article 2 of the Constitution.
So that's the law of the land as of this moment.
That United States versus Nixon is the law of the land.
Okay, now whether or not a president can be indicted while in office has been a discussion that's gone on for a very long time. Is that true in the legal world?
That's correct. The Department of Justice for the last 45 years has taken the consistent position through Republican and Democratic administrations that a sitting president may not be indicted while in office. The most thorough opinion on that is written by Randy Moss, who was head of President Clinton's Office of Legal Counsel in 2000. He's now a district judge appointed by President Obama on the district court in D.C.
I think you have written on this topic as well, haven't you?
I've not written on the constitutionality.
You're talking about whether or not it would be wise to do this.
I've made my thoughts known for Congress to examine because in the wake of September 11th, I thought one of the things Congress could look at is how to make the presidency more effective.
I just want my Democratic colleagues to remind you that when President Clinton was being investigated, you took the position that he's not above the law, but in terms of indicting a sitting president, it would be better for the country to wait. And the person who echoed that the most, or at least effectively, I thought, from his point of view, was Joe Biden. So there's nothing new here, folks. When it's a Democratic president, they adopt the positions that they're arguing against now, but that's nothing new in politics. I'm sure we do the same thing. So this man, Judge Kavanaugh, is not doing anything wrong by talking about this issue the way he talks about it. What we're doing wrong is blending concepts. To justify a vote that's going to be inevitable, you don't have to play these games to vote no. Just say you don't agree with his philosophy. You don't think he's qualified. But the thing that I hate the most is to take concepts and turn them around upside down to make people believe there's something wrong with you. There's nothing wrong with you. The fault lies on our side. Most Americans, after this hearing, will have a dimmer view of the Senate, rightly so. I don't want anybody to believe that you stole anything. Did you steal anything from anybody while you were working at the White House councils?
No.
Did you know that anybody stole anything, or did you encourage them to steal anything?
No.
Did you use anything knowingly that was stolen?
No.
So you can talk about Mr. Miranda, and he deserves all the scorn you can heap on him. But I don't want the public to believe that you did anything wrong, because I don't believe you did. So it's okay to vote no. But it's not okay to take legal concepts and flip them upside down and act like we're doing something wrong on the Republican side when you had the exact same position when it was your turn. Roe v. Wade. You've heard of that case, right?
I have, Senator.
Okay. Now, there are a lot of people like it, a lot of people don't. It's an emotional debate in the country. Is there anything in the Constitution about a right to abortion? Is anything written in the document?
Senator, the Supreme Court has recognized the right to abortion since the 1973 Roe v. Wade case and has reaffirmed it many times.
But my question is, did they find a phrase in the Constitution that said that the state cannot interfere with a woman's right to choose until medical viability occurs? Is that in the Constitution?
So the Supreme Court applying the liberty...
It's pretty simple. No, it's not, Senator Graham.
Well, I want to...
Those words.
I want to be very careful, because this is a topic on which...
No, if you'll just follow me, I'll let you talk. But the point is, will you tell me, yes or no, is there anything in the document itself talking about limiting the state's ability to protect the unborn before viability? Is there any phrase in the Constitution about abortion?
The Supreme Court has found it under the Liberty Clause, but you're right that specifically...
Is there anything in the Liberty Clause talking about abortion?
The Liberty Clause refers to liberty,
Okay,
but not,
well,
does not
last
have
time I
specific-
checked, liberty
Yeah.
didn't equate to abortion. The Supreme Court said it did, but here's the point. What are the limits on this concept? You had 5, 6, 7, 8, or 9 judges. What are the limits on the ability of the court to find a penumbra of rights that apply to a particular situation? What are the checks and balances of people in your business, if you can find 5 people who agree with you, to confer a right, whether the public likes it or not, based on this concept of a penumbra of rights? What are the outer limits to this?
The Supreme Court in the Glucksberg case, which is in the late 90s, Justice Kagan talked about this at her hearing, is the test that the Supreme Court uses to find unenumerated rights under the Liberty Clause of the Due Process Clause of the 14th Amendment, and that refers to rights rooted in the history and tradition of the country, so as to prevent...
So let me ask you this. Is there any right rooted in the history and traditions of the country where legislative bodies could not intercede on behalf of the unborn before medical viability? Is that part of our history?
The Supreme Court precedent has recognized the right to abortion. I'm sorry.
But I'm just saying, what part of the history of our... I don't think our founding fathers, people mentioned our founding fathers, I don't remember that being part of American history. So how did the court determine that it was?
The court applied the precedent that existed and found in 1973 that under the Liberty Clause...
Yeah, but before 1970, I mean, when you talk about the history of the United States, the court has found that part of our history is for the legislative bodies not to have a say about protecting the unborn until medical viability. I haven't, whether you agree with it or not, I don't think that's part of our history. So fill in the blank. What are the limits of people in your business applying that concept to almost anything that you think to be liberty?
And that is the concern that some have expressed about the concept of unenumerated rights.
Well, here's the concern I have, that you got one word that has opened up the ability for 5 people to tell everybody elected in the country, you can't go there. That this is an off limits for a democratic process. Whether you agree with Roe v. Wade or not, just think what could happen down the road if 5 people determine the word liberty means X. The only real check and balance is a constitutional amendment. to change the ruling. Do you agree with that?
Senator, I'm not going to comment on potential constitutional amendments or
But,
what.
okay, if we passed a statute tomorrow in Congress saying that the Congress can regulate abortions before medical liability, wouldn't that fly in the face of Roe v. Wade?
So the Supreme Court has said that a woman has a constitutional right
Doesn't that trump a statute?
the Supreme Court
So
precedent.
all of us could vote. Just 5 people have said liberty means right to the state has no interest here, compelling interest before medical viability, that we could pass all the laws we want. It doesn't matter because they fall. The only way we can change that is a constitutional amendment process that requires 2/3 of the House, 2/3 of the Senate, 3/4 of the state. Is that a pretty correct legal analysis?
When the Supreme Court has issued a constitutional ruling,
Then you can only change it by constitutional amendment.
that's the.
So here's the point. Whether you agree with Roe v. Wade or not, the reason some legal scholars object to this concept is breathtakingly unlimited. Whatever 5 people believe at any given time in history in terms of the word liberty, they can rewrite our history and come up with a new history. And I think the best way for democracies to make history is to have the courts interpret the Constitution, be a check and balance on us, but not take one word and create a concept that is breathtaking in terms of its application to restrict the legislative process. Now, whether you agree with me or not, I think there's a genuine debate. And you would agree with me if it was something you liked or you were supporting that got shut out, or you opposed you couldn't do. So I hope that one day the court will sit down and think long and hard about the path they've charted, and not just about abortion. Whether or not it's right for people in your business on any given day, based on any given case of controversy, to say that the word liberty, looking at the history of the country and the penumbra of rights, means X, and it shuts out all of us who have gone to the ballot box and gone through the test of being elected. All I ask is that you think about it. Also, I want to ask you about something else to think about. You said you were in the White House on 9/11. Is that correct?
That is correct, Senator.
Did you believe America was under attack?
Yes. It was under attack.
Right. Do you believe that if the terrorists could strike any city in the world, and they had you get a one shot at the world, based on your time in the White House, do you believe they'd pick an American city probably over any other city?
Well, it certainly seemed that New York and Washington, D.C. were the 2 targets.
The only reason I mentioned that to my good friends, and they are, who believe that America's not part of the battlefield, it sure was on 9/11. The law. If an American citizen goes to Afghanistan and takes up the fight against our forces, and they're captured in Afghanistan, the current law is you can be held as an enemy combatant in spite of your citizenship. Is that correct? Is that the Hamdi decision?
That's what the Supreme Court said in the Hamdi decision with appropriate due process findings.
Absolutely, appropriate due process findings. Here's what I want people in your business to think about. Are you aware of the fact that the radical Islamic groups are trying to recruit Americans to their cause? That they're over the internet trying to get Americans to take up jihad?
Yes.
The likelihood of an American citizen joining their cause is real because it's happened in the past. The likelihood of it happening in the future, I think, is highly likely. If an American citizen attacking the embassy in Kabul can be held as an American citizen, here's the question. Can an American citizen collaborating with other terrorists who are not American citizens be held as an enemy combatant for attacking the Capitol? And if they can't, you're incentivizing the enemy to find an American citizen because they have a privilege that no other terrorist would have. So you said something was very compelling to me, that you apply the law and you have to understand how it affects people. Right?
Yes, sir.
I hope you will understand that this war is not over, that the war is coming back to our shores, It's just a matter of time before they hit us again, because we have to be right all the time, and they have to be right one time. I hope we don't create a process where if you can come to America, you get a special deal. Makes it harder for us to deal with you and find out what you know. We treat you as a common criminal versus the warrior you've become. That's just my parting thought to you. And you'll decide the way you think is best for the country. Is there anything you want to say about this process that would help us make it better? Because you're going to get confirmed. I worry about the people coming after you. Every time we have one of these hearings, it gets worse and worse and worse. You've sat there patiently for a couple of days. My colleagues have asked you tough questions, sometimes unfair questions. Your time is about over. You're going to make it. And you would probably be smart not to answer at all, but I'm going to give you a chance to tell us what could we do better, if anything.
Senator, I'm just going to thank all the senators on the committee and all the senators I met with who are not on the committee for their time and their care. And as I said, each senator is committed to public service and the public good, in my opinion. And I appreciate all the time of the senators. And I'm on the sunrise side of the mountain, and I'm an optimist about the future, Senator.
Thank you very much.
Yeah. Before we break, I want to bring up some information, because I was wondering how long it would take the National Archives to get the material that we needed, because you've heard several times that the archives, that's their responsibility. The National Archives has 13 archivists who handle George W. Bush's presidential records. They can only review about 1,000 pages per week. We could not have gotten these documents for 37 weeks if we didn't get President Bush's team to expedite the review process for the benefit of all members of the committee. We received all the documents we would have received from the archivists just as a faster time. We'll now take 15 minutes and resume at 12:22.
So it looks like the confirmation hearing for Judge Kavanaugh is taking a bit of a break, a 15-minute recess. And today, I think, was not perhaps as passionate or as ruckus as yesterday was. There were a few protesters, but nowhere near what we saw yesterday. But it started with some fireworks with Cory Booker. And we didn't know at the time what he was talking about initially, but he was talking about the release of a memo that was eventually leaked as the confirmation hearing was unfolding.
Mm-hmm. The memo, in fact, had to do with Judge Kavanaugh's writings on the controversial Roe v. Wade decision, and also with something related to affirmative action. Cory Booker wanted to release the memo. The other side argued that it wasn't being released because of national security interests. He got into it a little with Senator John Cornyn of Texas. Cory Booker essentially saying, look, I'm willing to give up being a senator to release this information, and if you want to go after me for being a senator, bring it, is the quote that he said. Ultimately, it was introduced into the record, and Senator Feinstein asked him about it. And as he has over the course of the last couple of days, he sort of used judicial precedent in naming the fact that the current members of the Supreme Court have not answered questions regarding cases that could come up before the bench. Although he did address what he was trying to say in the email that was being referenced.
I think we have that exchange, a little bit of that exchange with Cory Booker, if we could play that so people get an idea.
No Senate rule and no history of the Senate accounts for what is going on right now. There was that was following this archives, this partisan operative, following his involvement in this process that I think, in my opinion, undermine the process. And the idea that we could somehow go through your lengthy process, and these documents many of these documents are dumped us in the last minute, but to Senator Cornyn actually made a very good point. I knowingly violated the rules that were put forth, and I'm told that the committee confidential rules have knowing consequences. And so, sir, I come from a long line, as all of us do as Americans, and understand what that kind of civil disobedience is, and I understand the consequences. So I am right now, before your process is finished, I'm going to release the email about racial profiling. And I understand that the penalty comes with potential ousting from the Senate. And if Senator Cornyn believes that I violated Senate rules, I openly invite and accept the consequences of my team releasing that email right now. And I'm releasing it to expose that, number one, the emails that are being withheld from the public have nothing to do with national security.
So ultimately, that email was released into the public record. We also want to play for you, our audience, an exchange with Senator Dianne Feinstein.
And it's sort of connected to that email because ultimately that email is released, and a portion of it has to do with Roe v. Wade and whether or not Judge Kavanaugh believes that it is settled law, a comment that he suggested be removed from a memo. So Dianne Feinstein asked him about that. We can play that.
So you believe it's correctly settled, but is it correct law in your view?
Senator, there's on that case or on Dickerson or on cases like Citizens United or Heller or United States versus Lopez or Kelo, just the whole body of modern Supreme Court case law, I have to follow what the nominees who've been in this seat before have done.
Judge, a yes or a no will do.
Well, I'm just if I can briefly explain.
Yes, you can.
Briefly, I'll try to be brief. But when you're in this seat, I'm not just sitting here for myself. I'm sitting here as a representative of the judiciary and the obligation to preserve the independence of the judiciary, which I know you care deeply about. And so one of the things I've done is studied very carefully what nominees have done in the past, what I've referred to as nominee precedent. And Justice Ginsburg, but really all the justices, have not given hints or forecasts or previews. And Justice Kagan, I think, captured it well, as she often does, in talking about questions like the one you're asking. You can't give a thumbs up or thumbs down and maintain the independence of the judiciary. So I need to follow that nominee precedent here.
So the nominee precedent is that don't go on the record about anything if you don't have to.
So that's where we are right now. We expect that this hearing will pick up again in about 15 minutes or so. But while we await for Judge Kavanaugh to get back into that Senate hearing room, let's give you a little bit more of what's happening outside of Washington, D.C., including this shooting that happened in Cincinnati. Several people have been killed during that course of that shooting, and it happened earlier this morning at a bank in the downtown area. We've learned at least 4 people are dead, including the suspect.
It's unclear if he took his own life or if police killed him. Officers addressed the shooting a little bit earlier.
What I can say, our officers responded very quickly. They engaged the threat and they neutralized that threat. However, there was some tragedies that did occur. You know, these are things that we see happening across the country, and we all have to be vigilant and prepared to deal with these situations. I think from what I see preliminarily, the bank responded with their lockdown procedures as well as our officers responding to the danger. So we will have more to come as soon as it becomes available.
Well, the FBI and the ATF are both on the scene helping local police investigate. So stay with us throughout the day, and we'll get more information as this story develops. We are going to take a quick break for now, though. We've got a lot more breaking news ahead. This is